Good evening and welcome to another exciting adventure with Coeur d'Alene City Council. It is March 5th, 2024, and I will call this meeting to order. The clerk will note that all council are present, and we have an invocation tonight by Stuart Bryan from Trinity Church. Welcome, sir. And if you'd please stand for an invocation, if you are comfortable with that.
Thank you for having me.
Thank you for coming.
Let's pray. Almighty and eternal Father, you revealed your moral law through Moses and your grace and truth through your Son, Jesus Christ. We bless you for the fullness of your revelation, for the good fruit that it has borne in our land. Our first president, George Washington, once asked, "Where's the security for property, for reputation, for life, if the sense of religious obligation desert the oaths which are the instruments of investigation in the courts of justice?" He knew that no society may prosper apart from fearing you. And so we pray for our republic, the United States of America, for our state, the great state of Idaho, for our city, the city of Coeur d'Alene. We pray that you would fill our hearts and minds with a proper reverence for you and for your commandments. Through your Son, Jesus Christ, make clear to us your commandments, transform our hearts that we would love them, and grant us your Spirit that we might obey them. Specifically, I ask that you grant wisdom to this, our city council, and to our mayor, that these men and women would love righteousness and would serve this community diligently, faithfully, sacrificially, and in the fear of your name. This I ask through Jesus Christ, King of Kings and Lord of Lords. Amen.
Amen. Thank you, Pastor. And Woody, would you please lead us in the pledge?
I would be honored, sir. I
I
pledge
pledge
allegiance
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Are there any amendments to the council? Seeing none, we'll move on to presentations. And the first is a proclamation regarding Red Cross Month. And I will read some of this proclamation. Whereas during American Red Cross Month in March, we celebrate the humanitarian spirit of Coeur d'Alene and reaffirm our commitment to help ensure no one faces a crisis alone. And whereas caring for one another is at the heart of our community and exemplified by the people of Coeur d'Alene, whose simple acts of kindness through the Red Cross provide help and hope in people's most difficult moments. Continuing the life-saving legacy of Clara Barton, who founded the organization more than 140 years ago to prevent and alleviate human suffering, and whereas every day these ordinary individuals lend a helping hand to make an extraordinary difference for neighbors in need, and whereas their support, volunteerism, and generous donations are critical to our community's resilience, we recognize hereby this month of March in honor of all those who fulfill Clara Barton's noble words: "You must never think of anything except the need and how to meet it, and ask everyone to join in the commitment. Thou, therefore, I, Jim Hammond, Mayor of the City of Coeur d'Alene, Idaho, do hereby proclaim the month of March 2024 as Red Cross Month and encourage all citizens of the City of Coeur d'Alene to reach out and support its humanitarian mission." And we have Chet Rochecto. Did I get even close to that, Chet?
You got Chet down pat.
Thank you for representing the Red Cross tonight. If you heard it there,
Yeah,
share.
this is just a share minute. Thank you very much.
Thank you. But first, share with us your name as it's appropriately pronounced.
Yes, don't worry, I've heard it all. So,
My name is Chet Rashutko. I am a board member of the Greater Inland Northwest chapter of the American Red Cross. Takes us through Northern Ohio. I'm from Ohio. Sorry about that. I'm from all of Northern Idaho for the most of the west side of the state of Washington. It's actually the largest region in the nation for as far as size. So we cover quite a bit here. And so thank you, Coeur d'Alene, and for the long history of being supportive of the American Red Cross, of all the things we do, the emergency responses we have to make on a given basis. And never more bigger example than Medical Lake, Washington last summer when the town was almost lost. Due to a tremendous response by fire and first responders, and then by the Red Cross. Families were saved, animals were saved, and we're well on the road to recovery. But we never know where the next medical lake will be, so I know that Coeur d'Alene stands ready to support us. If I could just make one pitch for all in the city is the need to continue to give blood. The number of people who give blood continues to reduce. The population who is qualified to give blood continues to be reduced on a percentage basis. So where you can, the most immediate need for the Red Cross right now is to be supportive of blood donation and platelet donation. We are the service that provides 40% of that blood to the hospitals. So where you can help and where we can get that public message out, we would be grateful. Mayor Hammond, Council, thank you so much for your time tonight.
Thank you. And now we have a presentation by Captain Walter regarding some bicycles. Those are healthy-looking bicycles. Welcome.
Good evening, Mayor and Council. I was asked to come present on law enforcement's response to downtown this summer and some of the results we had from last summer. Let me pull up. Where? Just enter. Yes, please.
I mean, we upped security.
Right?
He didn't have the clearance.
Sorry. what-
We're even locking Renata out.
I'm just learning a lot of passwords recently, so, it's taken me a few moments. I have you open up down here. There you go,
Great,
sir.
thank you.
Software update.
Historically, downtown, we respond to a lot of law enforcement issues. With the population increase in the summertime, being a destination city, it drives some crime trends that we try to get ahead of. A lot of those are alcohol-related issues, such as fights and property damage. Vehicle noise, thefts, some gang activity, and juvenile problems is also what we deal with. Last year, one of the things we did to get ahead of this was we deployed a downtown bar team. The first part of the summer, usually we start this at about May 1st, the first part of the summer is spent building relationships with downtown business owners and citizens on the streets, and just kind of start that relationship because prevention is usually a lot of what we do. It was reported that the bar meeting last year was the best bar meeting we ever had. We had a lot of good relationships that are still standing with bar owners. Alcohol-related issues, DUIs, fights, those kind of things are something that we dealt with a lot of in 2020, and we just realized we needed a change in the way we approach that. And so the bar team was the team that built of 1 sergeant and 4 officers, primarily Wednesday through Saturday, and they were proactive with meetings in bars and businesses, and they would vary their shift based on the crime types that we had. At the end of that, we had a lot of success. We were able to curb a lot of the crime that we usually deal with, but I did recognize that there was a hole in service or a gap in service, and it made me think back to the time when we had bike patrols deployed downtown. So part of the 2024 mission is to have 7 days a week coverage, spend, in addition to the bar team, spend more days in the park. There was a little bit of gap in service because the bar team worked later at night. We missed some opportunities to engage with our public. Also, reduce crime in the parks in that earlier time period. So part of the mission is 7 days a week coverage, midday to evening bike team, nighttime bar team, and community outreach. The bike idea was good, but we had to do it a little bit different. We wanted to deploy it in a way that it should be deployed. We don't want to do things that are, we want to be the most efficient that we can. And so I was able to secure a grant to buy e-bikes, and that does a couple of things for us. Having served on bike patrol myself, I know that when you're responding to emergency, it's very difficult to handle the emergency when you've had to ride 3 miles. So e-bikes were a good answer to that. We brought some with us. This company specializes in police bikes. I bought 6 of them. I secured a federal grant for $31,770 to pay for that. It's going to pay for the whole program. We'll be the first in the country to use federal dollars for an e-bike program, and so we get to participate in a study as well that other cities will look to us as the example to build their own bike programs. 6 bikes in total. We will deploy 4 in the parks. The e-bike also allows us to expand our reach, so we'll be able to cover all parks to include the Atlas Park, which we wouldn't normally be able to get to on pedal bikes. We'll expand our reach north into some neighborhoods as well as all the way down to the east side. A lot of what we do in police work, the technology part of it, keeps us in our cars. It's hard to engage with the community when you're in a car. And so the other e-bike benefit is that it gets us out of our cars, it gets us interacting with the community to fulfill that part of our mission. People like them. They're cool looking, as you can see, and so we get a lot of questions, we get a lot of engagement just being in the parks on those. So we'll deploy 4 in the park. I bought 6 so that we could deploy them on special events. They are all weather bikes, so you can deploy them year-round for special events. Detective Carroll is our bike expert, so I brought him down in case you have questions about the bike specifically, but I can answer questions about the program. And that's kind of what we're thinking for summer of 2024. So with that, I will answer any questions that you have.
Questions? Yes.
Well, I know that there are different classes of bikes, so I don't know if it's the class and the top speed of this is classified, but I mean, when you mentioned if you got to get from, the park to, 7th and Sherman, and so I'm guessing they're speedy but safe.
They're safe. I would say they're probably the fastest on the market if you're asking about the speed.
Okay, good to know. Okay, so don't try to outrun one if you're.
I don't think it's ever a good idea to try to outrun the police.
Yeah.
The radio goes faster than the bikes. The bikes will top out, I think, at about 30 miles an hour.
About 30 miles an hour, yes. Depends on the rider, but about 30 miles an hour.
Yeah.
And it's not a situation where they have the motor on all the time. Most of the time,
sure.
they'll be pedaling.
And one of the things, I guess, it's secondary to maybe the mission of this, but have had a lot of people who have kind of complaints about the speeding on the trails, like Atlas Trail and that, and the people who don't appreciate it's 15 miles an hour, and actually a lot of the pedal bikes, guys getting ready for triathlon.
That is
So
definitely.
I don't know if you'll be looking at some of those kind of courtesy warning tickets or something.
Definitely part of the mission, right? Just to make the park, that's one of the
And the
things we
trails
recognize is
safe.
we address the bars and some of those issues downtown and retail theft and that type of thing. I felt that there was a gap in service in the parks and the trails, and so absolutely anything to make that safer
Yeah,
would be something that we would be responding to.
good.
Christie?
Thank you. Captain Walther, you talked a lot about the, I guess there's a level of accountability since it's a federal grant.
Yeah.
So what kind of data and stats are you going to be keeping track of?
So the effectiveness on the community outreach part is a big part of what they would like to know. Bike patrols are known for increasing that type of thing, and so we want to track that. Our ability, as far as just interactions, the statistical interaction piece of that, our use of them to, what is the effect on crime rate in that downtown area by deploying a bike program, that's something that we're going to track. They haven't given us the list, but those are the ones that we've talked about so far. I'm sure that there'll be more. How effective the e-bike is, right? Is this company, did they build a bike that is applicable for police programs? And I'll be honest with you, we did a lot of research, and this is the #1 program in the country as far as the company that, they're the only ones that make this thing. This is a
Great,
very specialized piece of equipment.
excellent, thank you.
Woody?
Oh, quick one. So the nighttime bar team isn't on bikes, is that correct?
Oh, no, sir, they're on foot and oftentimes in vehicles, depending on what they need to do. So this will be in addition to that. We put them on foot, again, for the community engagement piece. If you've been downtown in Coeur d'Alene, you know that there's a lot of foot traffic. And so we want those guys intermixed with the public and visiting with the bar owners and the bar staff, as well as retail establishments during the daytime to curb theft and that type of thing.
All right, thank you.
Kiki?
Thank you, Mr. Mayor. Captain Walther, I just want to say I think this is great. I appreciate the initiative to get this out there, the high visibility, and being able to get into places where patrol vehicles couldn't go. I would sure appreciate an update at the end of the summer when you're done gathering this data to see how
Absolutely.
things went. I'd really like to hear that. I think the community would like to see how these are and how they can support them if we have a real successful program. So thank you for the effort.
For sure.
Dan?
Oh, Mr. Mayor, I was just going to say, I'm looking forward to a ride-along.
We got you. We'll send you some training and get you a helmet.
All
The
right.
basket, he needs a basket.
Basket, for sure.
Sidecar.
Any other not just about the bikes, but about the downtown enforcement program that we deploy at all?
I think it's a good effort.
Thank you, Captain.
Yeah, absolutely.
Thanks, Cap.
Thank you.
Thank you, guys.
Okay, we've got several folks wishing to share their wisdom with us tonight during public comment. Tom? Where's Tom? La Riviere.
He's here to speak in regard to the appeal.
Yeah, so
later.
I was going to just say that you don't need to speak now. Sam Johnson from Post Falls.
Thank you. Sam Johnson, 2535 Tieton. Mr. Mayor, council members, thank you for your time. I'm here in opposition of Council Bill 24-1002, specifically sections 3 and 4. Let me tell you what I believe this does is criminalize car enthusiasts for owning a basic car part. Let me tell you who would be guilty of a misdemeanor under these new sections. Coeur d'Alene Cars and Coffee, 1,800 members. The vast majority with modified cars, because that's what car enthusiasts do. Criminals. Autosports Northwest, that's a group I race with. Once a month, we get together and we take our cars to the racetrack, and we do autocross and time trial racing. Criminals, a lot of them under this. Coeur d'Alene, the city itself invites thousands of car enthusiasts to the city every Father's Day weekend. You do make an exception for events, but don't stay till Monday, otherwise you're a criminal. Flowmaster has an R&D facility in Hayden. They engineer performance exhausts right here locally. Don't cross prairie, otherwise it's illegal. The issue at hand is not the car part, it's the conduct. And the existing code already prohibits that conduct. It says, the following is prohibited: operation of any automobile in a manner as to create any loud, unnecessary, or unusual noise that is excessive, disruptive, or annoying. Clear and unambiguous, addresses the conduct at hand. In your own city, in the city's own slides that you'll see here soon, it states, in many cases, the vehicle noise issue is not the ongoing noise of the motorcycle or automobile engine itself, but drivers, often visitors, that take great pleasure in revving their engines to gain attention. That's conduct. And the new law doesn't prohibit any conduct that's not already prohibited. What it does is prohibit car parts. So it penalizes residents for the conduct of visitors. So I'd agree that noise is an issue, that the conduct is an issue. I'd agree that raising the penalty could resolve some of those issues, but I believe that can be done without prohibiting car parts and instead criminalizing car parts and consequently criminalizing car enthusiasts. Thank you for your time.
Thank you. John Deuce, Coeur d'Alene.
This is my first time before the council
Well,
members.
welcome, sir.
This will be short. I'm commenting about the Chapter 10.8, the CDA Municipal Code regarding noise. Again, my name is John Doyce. I'm a full-time resident of 301 North First Street. I'm speaking to you with the approval of the HOA president, Ken Edwards, and I represent the 200-plus residents of Coeur d'Alene North. We wholeheartedly approve of the modifications to the municipal code. However, the enforcement phrase, loud, unnecessary, unusual noise that is excessive, disruptive, or annoying to a person of reasonable sensitivities without an upper decibel limit may prove problematic for the police department. I don't know how they determine that. So my question is, how is the city police department going to enforce this code on Sherman Avenue Northwest Boulevard between First Street and Garden Avenue? This is a section of street that has a 25-mile-per-hour zone and is regularly ignored, especially on Fridays and Saturdays. My comment is, noise is the most serious issue for residents of our building and also One Lakeside. While speed also poses a safety problem on this section of Sherman Avenue. They come around the corner past the visitor center, and if there's a green light down on Garden, they hit it. It's a drag race. Question 2, will you consider installing real-time noise detection and speed monitoring equipment at appropriate locations on this section of Sherman Avenue and Northwest Boulevard? That is, something that will detect a violation and then, with cameras, issue a ticket, a speeding ticket. And I've done some research in Canada and in France and some U.S. cities that have attacked this problem, and they've been relatively successful recuperating their money. My last comment is a tragic note. A high school classmate of mine and her 2 children were struck and killed by a speeding driver who lost control of his car, jumped the curb, and killed Gretchen and her 2 children. And the road was very similar to Northwest Boulevard. So that is a big concern. If we go back to September 8th, 2023, the Honorable Bill Bewley wrote in the newspaper and quoted, "The noise emanating from speeding traffic and loud engines on Northwest Boulevard between Lakeside Avenue and Government Way is outrageously loud. This is especially true on weekends and weekend evenings. So loud are the motors and mufflers that John and Tish, my wife, can't carry on a conversation in our living room during eating meals without closing the doors. We've installed soundproof windows and doors, and it hardly helps at all. So any efforts you can make to limit the noise throughout the city, but we're particularly interested in Northwest Boulevard, would be really appreciated. And if there's anyone in the city that I could work with, giving him my research in Canada and France and the U.S., please let me know. I'd be happy to do it."
Thank you, and you're welcome to turn that over to our city clerk anytime, who will get it to our engineering folks.
Okay, I made a number of copies if you'd be interested. Thank you for your time. I appreciate it.
Thank you, sir. Bill Breezy, Hayden.
Yes, Mr. Mayor, council people, council persons, thank you for listening. I am back again to talk about the traffic control of, local control of the traffic lights. After your last meeting, I was interviewed by the CDA Press, and I am here to correct a few things that were in that article. The reporter interviewed Glenn Miles, who's the director of KMPO, and he basically stated that without the Traffic Management Center, that you can't control traffic lights, you can't synchronize traffic lights. That is absolutely not true. I don't know whether it was a misrepresentation or what, but that is not true. In fact, in a meeting that Councilperson Gookin and Wood facilitated last year on a different subject, I talked with your traffic engineer about this, whether he could control, the lights on 95 and Government, and he said all he needed was a data point inside City Hall. So that's all that's necessary, so that was not true. He also stated that U.S. 95 is a U.S. highway, and that there's no way that the federal government is going to allow the state to have the control of those lights be local. And last year, there was 2 open houses with ITD. And in both cases, I asked them the same question. I said, can we get control over 95 and both directions of government? And they both said, well, all we need is an intergovernmental agency agreement, and it's done. So here the director of KMPO is leading the readers to something that's really not accurate. He also did spend a lot of time talking about the issues with traffic, coordination and certain directions have priority. And I think we all realize that traffic, you're going to stop at red lights. It's inevitable. But what we're trying to do is create the optimum flow to get the most people through during the time of the day that it's needed. And I was going to be at Post Falls with the same speech that I did at your last meeting, but I wanted to come here and make sure that I corrected this, and so that you all know, and I hope that you're still, considering the resolution, because we really need to get the traffic lights synchronized, and I thank you for your time.
Thank you. Michael Newell?
I'm on the appeal.
Oh, okay. Emily Boyd?
Good evening, Mayor and Council. Emily Boyd here on behalf of the Downtown Association. I am here tonight as the MOU for the St. Patrick's Day Parade is coming before you, and I'm happy to answer any questions once Renata gives her presentation. But while I was here, I also wanted to thank you all for those of you who participated in the strategic planning interviews. That work is really coming together. I met with consultants again today, and our steering committee is gathering again this week. And we're hoping to have a full approved strategic plan by May, June, and hopefully we'll get the opportunity to present that to you all. And then also I wanted to give an update on some numbers. I know council had asked for the events for some feedback on economic impact. And January 1st, we started with University of Idaho on those studies, and just some fun numbers for the first 3 events that we had in this winter season. 95% of the respondents came to downtown specifically for the events that we were hosting, and 60% of them made a retail purchase, and 69% of them noted that they participated in some sort of dining or eating, drinking activity. So those are just very brief preliminary numbers. Our impact studies are not completed yet, but I was able to pull little tidbits from them. So I think those are going to be highly effective as we move forward and come before you with a full MOU packet for our other events. And then lastly, I just wanted to commend the police department, Captain Walther and Chief Lee. We had a wonderful impact on the downtown. That team that was down here was really impactful, and we're really excited to see it back again for this summer with the bikes improved. So that's all. Thank you.
Thank you. I would ask for, first of all, council announcements. I'm skipping ahead. Kiki.
Just a couple, actually one kind of really important thing to me. Historic Preservation Commission, I wanted the rest of council to be aware that there's an open house on April 8th for the Garden District conclusion of their program, but also that the commission has a real focus on the downtown preservation efforts. So there is funding being applied for. They'll know about that sometime in March, whether they get that. And that'll be to do the same thing they did with the original Garden District, to reach out to the landowners and folks who have an interest in preserving downtown and getting that census drawn of what those buildings are, and then also finding out what direction the community wants us to move in that effort. So those folks are very engaged, and I wanted the rest of council to know that there's a focus on the downtown by the commission. May is Historic Preservation Month, and they're preparing a really quality presentation to bring before the council. So if you have any comments or questions you'd like to have included before they complete that, please reach out to Hillary. But there will be time for question and answers then. And May's also, since it is Historic Preservation Month, I just heard today there's going to be an open house at the Jewett House on May 1st. There'll be more information about that one, but there will be a lot of activities surrounding historic preservation. Thank you. Want to make sure you knew that.
Amy?
A quick question. Do you have more details on the April 8th open house?
It's at 6 p.m. at the Community Library Room.
Perfect.
And it's regarding Garden District. Thank you.
Dan?
Thank you, Mr. Mayor. So I just wanted to check in, as they're wheeling the coffin through the hallway, I just wanted to check in to make sure that they were testify on behalf of the city in opposition to the bill, because I believe in local control. I also believe that's a lot of government overreach. I also believe there's it's about private property rights, and we all have private property rights, not just people who exploit their house to make a profit. But it's a constitutional issue because we do have policing authority as a city, and slowly but surely our legislature seems to want to chip that away. So my hope is that the bill stays in committee, and I'll let you know what happens. Thanks.
Dan, who sponsored that?
Mr. Redman, who's a representative from, I believe, District 3.
Thank you for doing that. I appreciate that.
Thanks,
Yeah.
Dan. I also, sorry, I thought you said that, Dan.
Well, just I was glad to be able to attend the executive team meeting last week, which is a different department heads and stuff, and then now a council meeting member when they can attend that. So, I mean, I've always read the reports, but be able to kind of hear and see in real time is good. And I was able to confirm with Hillary, or in the planning department, there is a gentleman last fall, I think, that came to us that was, interested in, the Dark Sky Initiative, and, there's been a lot of things that, have kind of, in the priority shoot, been tough to work on. But she did say that she's having a meeting with him and looking, there's some other cities that have done things that are not, draconian, whatever, but trying to preserve what we can of that while we can. And so, anyway, appreciate that, and I'll look forward to going again sometime.
Thank you.
Sorry, I was just going to, I thought you said, I apologize for stepping on your conversation there. On House Bill 506, I believe there was already a letter written from the city
Yes.
on that one, and AIC is collecting those letters and has a longer testimony time than individuals, the Association of Idaho Cities. So I just wanted to let you know they are planning on presenting all those and testifying at the same time.
Thank you. All the effort we can put into it is good. All I do is think of the neighbors who don't have neighbors, and they have rights too, and that's important to me.
Absolutely.
To all
I
of
think
us,
it's
yes.
important to all of us, yes. Okay, I would appreciate affirmation of the appointment of Douglas Harrow to the Historic Preservation Commission.
So moved.
Oh, second?
We have a motion and a second. All those in favor respond with aye.
Aye.
Opposed with nay. Motion carries. Thank you.
Mr. Mayor, I'd like to move for approval of the consent calendar as presented.
Second.
We have a motion and a second. Discussion on the consent calendar. Seeing none, will the clerk take the roll, please?
Miller,
Aye.
Burse,
Yes.
Gookin,
Yep.
English,
Yes.
Wood,
Yes.
Evans.
Yes.
Motion carries. And we'll move on to other business. Is that different than new business? Is other business different than new business?
Other new business.
And we have an appeal regarding a pre-qualification of a contractor. And we'll ask Mike to come forth with his report first.
He employs over 240 employees. He did $80 million worth of public works contracts last year alone. And he basically is a very large and respected contractor within the area. Unfortunately, we have done contracts in other jurisdictions and other cities, and we went across the state lines into the city of Spokane, and we got caught up in a controversy there concerning prevailing wages. Prevailing wages means that the state of Washington prescribed that truck drivers, welders, certain contractors would have a prevailing wage based upon the Washington statutes. And we were of the opinion that we were a Idaho company and that we hired the people in Idaho. Our trucks and our employees and our company basically paid what we thought was a very good wage, and that based upon the fact that we were coming from Idaho to do the work in Washington, that the Idaho wage laws and contracts prevailed. We made a mistake. The Labor and Industries basically imposed upon us a very large penalty and basically disbarred La Riviere, Inc. from doing public works contracts for the city of Spokane for a period of 2 years. In order to protect the employees and protect the companies and protect the long-standing tradition that this company has had for the last 20 years in North Idaho, a new company was formed by the name of Alpine Contractors Group. It is owned by Mr. Tom La Riviere and the CEO of La Riviere, Inc., Ronnie Sanders. They are the sole owners. They were the managers, operators, the principals in La Riviere, Inc., and it became necessary for us to form another company and have that licensed in the state of Idaho as a public works contractor. We went through all the necessary things that we had to do. Mr. Riviere took the public works test. He provided the application. He provided the financials necessary to get the licensing and to be able to show his financial stability in regard to doing public works contracts. The city of Coeur d'Alene put out for bid a certain contract on one of its projects, and there was a pre-qualification of that bid, and we submitted our bid and our qualifications for bidding on that particular project under the name of Alpine Contractors Group, a licensed public contractor. The Public Works came back and said, well, pursuant to Idaho Code 67-208, there it outlined certain items and contracts over $200,000, which would be able to substantiate the ability to perform. And we basically had to provide contracts of similar size that we had completed on similar type projects, and we submitted 2 of those projects for our qualifications. The city came back through the Public Works Department and said that since this was under the name of Alpine Contractors Group, that we did not have the experience, we did not have the ability, we did not have the qualifications to complete that Public Works contract, and therefore disqualified us from bidding on that proposed project. We feel this is an injustice. It is not based upon statute, which says that if you have a public works contract in the state of Idaho, you can bid on any public works contract, and that the statute also said that in the event that that it is over $200,000, that you had to qualify for your abilities, your experience, and your qualifications for performing that contract. Mr. La Riviere has owned the previous company. He owns this company. It is he who is the body of work behind Alpine Contractors Group. He is the one who took the tests. He is the one that did the bonding. He is the one who gave the financials necessary to do that. But the Public Works contractors came, department came back and said, we are denying your qualifications based upon the fact that that you do have a public license, but the work experience, the qualifications, the employment, the ability to perform under this contract has not been demonstrated. By the large size of the public works contracts that we've done over the years, there's no question that we're qualified. And the disbarment in Washington only had to do with the fact that we did not recognize the prevailing wages, and it was not a question as to our ability to perform under the contracts. I've provided to certain exhibits, which I need to put in record in the event that this goes to the next level. But basically, we have complied with the requirements of the statute, and we have shown that Alpine Contractors Groups has the ability and the qualifications and the criteria necessary to perform this particular contract. It is obvious that the Public Works Department is trying to use the disbarment over in the state of Washington as a means to disbar us in the state of Idaho. That is something that has not been done in Idaho. That is something that is completely separate and apart. And basically, what they are trying to impose is that we do not have the ability to perform because it goes to the qualifications of our company to be able to perform. And there's a new, one of the exhibits that I've put in is a new contract that's putting out for qualification for bids. And you have the engineer JUB who's come to the Public Works Department and said, we have to change the qualification requirement, and we have to say that anybody that has been disbarred in any jurisdiction is not qualified to do business in the state of Idaho. And that if any employee, any shareholder, any manager, any officer, or any person who is involved with that previous company that has been disbarred in the city of Spokane is not allowed to work on a public works contract for the city of Coeur d'Alene. And I give reference to that in the new project, which I have provided you an exhibit as exhibit number 5, which the JUB basically said that, quote, Randy, is there any way to enhance the qualifications requirements? Is this apply organization or association parent company currently disbarred or suspended as a contractor or a subcontractor by a municipality or agency in any state? In applying, is the applying organization currently disbarred or suspended as a contractor or a subcontractor by any municipality or agency in any state, or has any officer, partner, shareholder, member, or principal listed in the application above an officer, partner, member, or principal in any other organization that is currently disbarred, suspended, or as a contractor or subcontractor by a municipality or agency. That's the state of Washington that we had to pay a fine of over $300,000, and the disbarment occurred. It has nothing to do with any of the violations of any of the state laws of Idaho, the city laws of the city of Coeur d'Alene, and basically is imposing upon a a disbarment by application in not taking our, qualifying us as a party who can, is qualified to bid under any public works contract for the state or for the city of Coeur d'Alene. I am entering into the record the letter dated 2/16/24 that says that this denial is based upon the fact that the company that holds the public license to bid on public contracts is in fact not the named party who gave the qualifications as to their experience and their ability to perform under this public contract. And so basically there is guilt by association and is imposing upon companies such as La Riviere the inability to even contract or put out a bid on any of the contracts that their history has shown that they are qualified, experienced, and have the ability to perform. We are talking about 240 employees. We're talking about $20 million worth of equipment. We're talking about hundreds of millions of dollars worth of public contracts that we have performed. We have the ability. We have the background. We have the management and the equipment and all of the things necessary to fulfill those contracts. And by imposing a disbarment by association is, I feel, not legal. And we feel that if that this is not the last, that this is going to be heard in the event that we are unsuccessful in trying to talk reason into the city council concerning the ability of Alpine Contractors Group to bid on public works contracts within the city of Coeur d'Alene.
Thank you. Now do we have Mike come up? Mike Anderson.
Try. Hopefully I don't have to know the password.
But I guess it's too secret.
Just try password.
Sorry, just give me a moment. Bring up a quick presentation here. So my goal here is to walk you through our reasoning for pre-qualification and just simply the steps that we went through, so everybody's on the same page, to hope give you an informed opinion on where we were coming from. So obviously this is regarding the 2024 wastewater open trench pre-qualification and Alpine's appeal of it. So what is this project about? Just to simply get everybody on the same page, this is 19th and 20th Streets, and along these streets is some 6-inch sewer pipe, and this project is going to be to replace that 6-inch sewer pipe with 8-inch pipe. Typically we would do the CIPP lining, as you're aware of, but 6-inch sewer pipe, if we were to line it, it would remain 6 inches, and that's just not something that we're really capable of servicing as well as we can 8-inch sewer pipe. Our standard is now 8-inch pipe. This is old, so we're going to be doing an open trench project, ripping up the streets along both roads here up to these manholes, and installing new sewer pipe for what looks like about 46 current connections at the moment. That could go down, but this would impact about 46 or so families, hence the reason for us to pre-qualify. We thought that the scope of this project was sufficient enough and the cost sufficient enough to ensure that we get somebody who has met several pre-qualifications, including previous experience. So that pre-qualification is broken down into 4 parts. In your packet, I did include the statement of qualifications that Alpine did submit. I'm not going to bring that up on this presentation, but I'm going to go through each part generically, and you're more than welcome to go through on your packet if you'd like to see what Alpine's statements were. So that being said, Part 1 is, there is no score given to Part 1, it's simply background information.
Excuse me.
Um,
Mike, just one
yes.
second. Is that page 3? Does it, I can't see this page. Are you
Oh,
on
I'm
the
sorry.
page that
So this is
says-
page 3 of 11 in the qualifications, correct?
Thank you. Sorry about that.
I'm looking for something. So on this statement of qualifications is where you would put in the name of the organization. What's the type of the organization? Is it a corporation? Is it a partnership? What is it? Now this, on the back of their packet, you can see it was submitted on February the 9th, and the name of the company was Alpine Contractors Group. Alpine Contractors Group submitted DBA with the state of Idaho on February 14th, 5 days after this was filled out. So in other words, this wasn't yet, Alpine Contractors Group wasn't even a company at the time of this submittal. But that was, no score is given at this point. That's just for your informational purposes. Part 2 is for the technical competence and experience of the company. So you can see this is page 6 of 11, it begins. Page 6 of 11, and they're asked 2 basic questions. Is the company, do they hold a public works contractor license? And then part B is the company's experience. Did they meet the prerequisite experience in similar fashion? So in other words, an 8-inch pipe, if they worked on an 8-inch pipe, have they done 20,000 lineal feet? Have they done something similar to this in the past, in the last 5 years? If you marked no on either of these, it would be a disqualifier. For that company experience, if you mark yes, we ask for the reference. Where is your reference to say, I have done 20,000 feet of 8-inch line? And this is where we ran into a problem on this application. The company's experience, Alpine Group, listed 2 projects, one for Viking and one for the city of Spokane. And neither, when we called it both of those projects, Alpine Contractors Group did not perform those projects. La Riviere had performed those projects. So being that Alpine Contractors Group was the company that applied for this, we deemed those projects to not be done by the applying company. So that was the disqualifier. Part 3 is the performance history, and again, this is a immediate disqualifier if you answer yes to any of the questions. So part 1 is debarment or suspension. Has your company ever been debarred in any jurisdiction? An answer of yes would be a disqualifier. And part 2, have there been any prior performance with issues with the city of Coeur d'Alene? And that was basically, have you done work for the city of Coeur d'Alene that has not been accepted? If that was also the case, then you would be disqualified. Part 4 is a reference check. We would call up the references on, so we had 10 applicants. We would call up the references given in part 2. These are the people that we had done work for in the past. We would call them up and ask them on a scale that broke it down into 4 different parts. One was personnel. What was the quality and quantity of the personnel? Did they have enough people there? If there were not enough people or not enough qualified people, they would get reduced points. If they got to the point where it actually cost the city money, then it would be 0 points. Any time that they scored 0 points on any of these, that too would be a disqualifier. So part 1 went over personnel, part 2 went over timeliness, were you on time with your project? Part 3 was compliance with standards, and then part 4 of this reference check was a claims history. We were not able to perform any of these reference checks for Alpine Contractors Group, again, because the 2 references that were given were not performed by Alpine Contractors Group. And that's simply the reason. company that applied for this did not meet the qualifications of pre-required work. So in conclusion, I would ask that you uphold the integrity of our pre-qualification project and of the 10 contractors that applied, and sustain the disqualification of Alpine.
Thank you. Questions? Go ahead.
I have a couple questions, and I'm not sure who to direct these to, so I'll let you guys figure out who wants to answer these. I want to make sure I'm following the businesses. And so can somebody confirm, under Alpine Contractors Group, the CEO is Ronald Sanders, and Tom, you're a shareholder?
No, I'm the owner.
You're the owner?
Yeah, I'm the owner and I'm the acting manager.
Okay, and then now let's talk about La Riviere.
Yep. La Riviere is owned by me and my father.
Okay.
So my father and me own La Riviere 50-50. So Mike did all the legal stuff. So we started working through the Alpine stuff, not just because of the debarment, but because of the fact that this is kind of my succession plan, right? Eventually, my father wants to retire. We want to turn the La Riviere Corporation into a family holding where it holds the equipment and it holds other things and it holds other stuff. So this is part of my succession and part of my transition. As my father retires and gets out of the business, I need a business partner because I don't want to do this forever. I want a succession plan to get myself out too. So Ronnie Sanders has been with me since 2005. I know you guys, lots of people have met him throughout the duration of La Riviere Corporation and different things. This is part of his growth too, right, is we wanted to start a partnership together. So that's the reason for it, is that piece of it. Mike spoke to a very important piece. My employees mean a lot to me. My employees mean everything to me. I think anybody that knows me as a businessman or as a human know that my people mean everything to me. When the state of Washington started coming after me, and I'll fall on that sword all day long, I made a mistake. But I made it right. Everybody got their money. I paid all my fines. I paid all my stuff, right? But to protect my people in order to keep their paychecks going, to keep their families fed, I started to build another piece of a protection, right? Because I had no idea what that state was going to do to me at all. So it's multiple facets, right? I also own several other companies here in town. Liberty Concrete, Creekside Landscaping, right? We've developed all these little things that we do as a self-performed contractor in order to break these things off for different family members. My wife owns Inland Traffic Control. So all these things are little pieces for the family.
Thank you, that's helpful. A second question is, on the application, page 3 of 11, it was mentioned that the date and state of incorporation, on the application I have here, it's 1/26/2011. I'm not sure how relevant this is. But Mike, did you say it was, can you repeat the date that you said?
Well, I can clarify that,
Okay.
I think. A company called Alpine Northwest LLC was incorporated in 2011. Alpine Contractors Group is not a separate company. It is a DBA of Alpine Northwest LLC. And Alpine Contractors Group, their DBA was filed with the state of Idaho on February 14th of this year, which was 5 days after the application by Alpine Contractors Group for the statement of qualifications.
Okay, thank you.
But it always was it's been a corporation since 11.
Thank you.
Alpine Northwest LLC has been, but not, which is not identified in the statement of qualifications as being any part of this.
Kiki, did you have a question?
Oh, I'll have a lot of them. I'm thinking, that was one of my questions, and so you're very diversified here with all of these different groups, and are you the one who is filling out these applications, or do you have an estimator, or is Mr. Sanders doing this?
We have an admin basically that goes through and helps me fill out all the paperwork in different bid forms and stuff like that. She's a contract admin, and then I review them, and then we put them together, and I'm the one who signs off on them.
I see a big hiccup with your dates not corresponding with applications and filling things out that way. What class of Public Works Idaho license is was required for this job?
I don't know what's required for this job, but we are an unlimited contractor.
Okay.
And again, that Alpine, just to be clear, Alpine Northwest LLC has the Public Works contractor's license. Alpine Contractors Group does not have.
So the big hiccup on disqualification here from what we've heard, what I've heard just now, is it's the DBA filing. If that would have happened prior to the date of the application, would we be talking about this?
No, so that was not the disqualifier at the time. We didn't dig into it. The disqualifier was the work, or lack thereof, lack of references given for Alpine Contractors Group. We did not do a review of La Riviere. La Riviere did not submit the application. Alpine Contractors Group did.
Okay, well, that's another question that I have then. If you contacted references and gave 0 points on 2 questions, but other points on other questions, who were you asking them about?
So we weren't able to do any of the reference checks. So for the points on part 4 where it says, how was your work? We didn't even do that. We couldn't do that because there was no there was no reference given for work that Alpine had done. It was work that La Riviere had done. So we didn't even check references. We couldn't because Alpine hadn't done the work.
Okay, I'm just trying to get what this in front of me is trying to explain to me. There's 5 different questions here. 2 of the questions have 0 points. 1 has 3, 1 has 4, and 1 has 5. So if you were grading somebody on this, who were you grading?
So those are the possibilities. And as we were going through that, if on those questions, on question 1, which says, how was your personnel? If the person had said, let's say, oh, they had the best personnel ever, and they were above board and beyond expectations, they would get 5 points. If they said, conversely, they didn't have enough personnel, they weren't qualified, and it costs us money, they would get 0 points. So those 0, the 2 zeros, the 3, the 4, and the 5 are just the options that could have been scored. Those are not actual scores. If we had done the reference check, we would have scored them with the appropriate score. But again, we didn't do a reference check because we didn't have a reference to check. Is that making any sense?
This is very confusing, Mr. Anderson, because it does look like you've gone through these pages and filled it out, but there's no, this is what they've submitted, and then there's no scores, but those are the possible scores. That's fine. Okay, so the next thing I had,
If I may, to help clarify, maybe a visual would help. Back onto the board here, so everybody's looking at the same thing. Did the contractor provide adequate personnel for the project? And this is, you can look at it as A, B, C, D, and E possible answers. If we had called Viking Homes and they said they were highly qualified personnel and they're available for the project, we would have circled this or somehow denoted it that's a 5.
so what you're saying is you called Viking Homes and said, did Alpine Northwest Contractors do this job? And they said, no, Tila Riviera did it. Then you just didn't ask any further questions?
Correct.
Okay. Okay. So on the application, again, one of your reasons to disqualify the applicant was that they said no, they had never been disbarred, and in your opinion, they had been disbarred. Was that true?
No.
Okay.
So in my opinion, Alpine Contractors Group has never been disbarred.
So, but they're not qualified, so you didn't take that part into consideration?
Once we got to step number 2, or part 2, which was the lack of references, that's an automatic disqualifier from being able to proceed, and we stopped right there.
Okay, so the rest of the questions that they filled out were a moot point at that time?
Right, there was no need to continue on.
Okay. Okay, and, well, you've already fessed up to that. You should have known that the prevailing wage goes with the job, not the state. So, but you've paid your debt to society on that one. Okay, so then, what we have is that, I mean, for me, I'm still walking through some of this, sorry, you guys, is that this is kind of a parent company that has multiple subsidiaries, and you're applying as the parent company credentials, but the subsidiary applicant. Does that summarize kind of what happened here?
Pretty much, yeah. And so if I understand, and granted, that's the reason I have lawyers. If I understand, every time that I go to take a test for a public works license for one of my new businesses, my work experience chases me. Everything has to do with me, right? My bonding's that way. Everything chases me. It doesn't chase my company. It chases me as an individual. My public works license does that. All those things chase me as an individual. And so as I qualify
For a company.
Yes.
And so when you took the test for
Alpine,
Alpine Northwest, not Alpine, the other one, Contractors, it was the same name, the same title,
yes, ma'am.
and the same license application.
Yes, ma'am.
Okay. I'm guessing I'm going to have more questions.
Woody?
Hey, Mike. Did you know it was Tom?
I probably have met him, honestly, but we're not very familiar with each other.
But he's done work for the sewer.
Oh, sure. La Riviere has, yes.
Okay.
His company, sure, certainly.
Okay, but so when you were going through these 10 applications, you weren't thinking he was de la Riviera, is that correct?
I knew of the affiliation because I've seen the sign on his building that says Alpine Contractor or Alpine something.
Okay.
La Riviere, the landscape company. Creekside, sure, in the northwest. But again, we
Just
really
going
try to
to-
go by
Gotcha.
as best we can what's written down on the paper. We try to keep it fair for everybody.
And he mentioned about the JUB building this. Did they build this?
Yeah, they helped us, so they're helping us with this project and putting this paperwork together and with the pre-qualifications and the entire project. They've helped with the design of it, and then they'll
So
assist
this-
probably with the construction as well.
So this is somewhat of a new approach, a new qualification system?
We haven't done it a lot, but we have certainly done pre-qualifications. It's not brand new.
But is it, the old one's the same as what we're looking at now, what you're talking about, or is this is new?
All the requirements that are written down on there, I think it's pretty do as to what it is. It's, do you have, most of the time it relates to, have you done the experience, and have you, has there been concerns with previous projects
Gotcha.
that would lead us to not want to select you, basically? It's really just trying to make sure that we get the best possible product at the end.
So my final question, and maybe it's inappropriate, but if you'd have known that it was La Riviera in the front side, would he still be in the game, you think?
If it was La Riviere, we would have gone through all of our projects with La Riviere and figured out, if you made me go out on a limb, I would probably have seen the debarment, and it would have been an issue, but
Ways, and that's what's confusing.
Sure.
We don't want you to know that we're debarred in Washington, so we've filed under Alpine, which you've done good work for the city. So I guess I'm trying to understand why you didn't just apply.
I'm starting to develop these pockets of things to protect my family, protect my children. I started the Liberty Concrete Division, for an example, to give to my daughter Brianna, because she's going to be filing for her female disadvantaged business license. She's a 22-year-old kid, and she's been in the business since she was in diapers running around with me on tractors. And so it's time for her to start transitioning into this as well. So I developed that for her. Her little sister will get the Creekside landscaping piece of it. Like I say, my wife Trina owns the inland traffic control. So we're just breaking this thing up as a conglomerate to all work together as a family, but to also protect the family as well. So this really had nothing to do with a cat and mouse game. It wasn't a sleight of the hand or anything like that. It is, we are moving our contracting work towards Alpine. And to be honest with you too, the correlation between Tommy LaRiviere and LaRiviere Inc. Is getting a little heavy for me on a personal level, right? Anytime anybody's mad at the company, they're mad at me because of the correlation of the last name, right? And so I am trying to kind of move this on to where people can manage it in a manner that they don't have to worry about the correlation of the last name with the individual as far as anybody that's, potentially upset. And to be honest with you, a lot of this movement too is protection for my kids. We're not always the most liked people in town. And my children have fallen out and taken the fall for that quite a bit in these last few years. And so I am moving a lot of this for protection of my children.
Okay. Ron, is that correct? Mike, I'm sorry. Hi.
We'll answer to anything.
Okay. Mike, you gave us a large packet.
Yes.
We can't read it while we're trying to pay attention to you. Skim it just a little bit, but that won't do. Did you include in here the debarment from the state of Washington so we would see all the details?
No, and I don't have any problems in doing that. If there's some further questions or further consideration in regard to that particular issue, I don't have any problems doing it. I just was making note of the fact that it looks like the city through JUB is trying to make a qualification and experience and everything based upon a disbarment. And it's not an issue in Idaho, it's an issue in Washington. But yet JUB, as the preparer of the contracts, is making an issue.
So you heard tonight our director say that he wasn't even aware of the disbarment.
But I read to you what JUB was saying, that we have to deal with this disbarment issue, and we want to modify the contracts to include that any disbarment of the company of La Riviera Inc. in Washington also disqualifies all shareholders, owners, managers, supervisors, the whole list of people. It looks like the city, to me, is the one that's imposing that, because on the new qualification on the exhibit number 5, this has gone out to the world for pre-qualification for another project. And it's basically now making it the big question. Have you as a company been disbarred in any other municipality? And where did that come from? I thought it came from the Public Works Department, but apparently it's coming from JUB. And was that done based upon instructions? Was it based upon Public Works going to JUB and say, we need to deal with this question concerning disbarment? That's why it's an issue, because in exhibit number 5, they are talking about saying that it's going to be a big balloon, a big umbrella that's going to cover all employees, all managers, all shareholders, all owners, and all managers who have been associated with a disbarred company. Boy, I would hate to be an employee trying to go out and try to find work with a competitor or start a new company, knowing that I'm up the creek without a paddle because of what the city of Coeur d'Alene is making it a requirement that this big umbrella disqualifies everybody.
Okay, thank you. Thank you for that. I think we probably have to have some more explanation from our city administrator and our Public Works director. Thank you.
Dan?
Thank you, Mr. Mayor. So as long as you're there, Mike, so you're talking about this that was included in our packet?
Yes.
That thing, you read that earlier. It says author is Jessica Waller. Who's that?
She's the chief engineer for the Public Works Department of JUB for the city of Coeur d'Alene.
Okay,
And
so,
JUB's under contract with the city of Coeur d'Alene.
and who is this letter to? It says Randy, but I'm assuming
I
that's...
don't know. That came to a packet from us just yesterday as to a new project, and that now they were changing the requirements in the project to say that this disbarment was the big issue.
Randy, can you provide a context for this?
I am that Randy.
You are Randy. So what was the Was this a response to an email? Was this something sent to you? How was it?
It was a request to me, asking how we could incorporate in future pre-qualifications. What is intended is to avoid a situation where an owner or a major shareholder, not just employees, create a new company to avoid the idea that their previous company may have been disbarred. I think I'm correct. Mike Anderson, correct me. Alpine was not the only one disqualified in this process for this project. Another company was, precisely for that same reason, that they were debarred from working for another municipality. So we were just trying to be all-inclusive in this. And I do want to point out that this only applies to pre-qualifications. Not all projects are pre-qualified. Right. So Alpine would not be disqualified if it were just a straight bid project, which most projects are.
Okay. I have a question for Mr. Anderson. Can you explain a little bit about debarment? So this is the first time I've used that word in my life, so I'd like to understand a little bit about what that means and how it plays a role in your decision-making process.
So debarment to us means if you have been either through somebody telling you, in layman's terms, so what I speak. If somebody tells you can't work for us anymore, municipality, let's say, says you can't work for us anymore, or we also view it as or for a period of time. Usually it's 5 years or something like that. Or if you come to a mutual agreement, hey, we both agree that I won't bid on any of your projects for the next 5 years. For whatever reason, an agreement not to work for each other for a period of time is what we're using as debarment. And that's my layman's understanding of a legal term.
Okay, so it's basically some city somewhere, anywhere, I guess, there's no limitation on this as far as the city of Coeur d'Alene is concerned. It's just any municipality anywhere in the United States for any reason whatsoever lobs a debarment at a contractor, that's a disqualification.
Yeah, that's how it's written. What we've seen in this instance, in this pre-qualification instance, was local contractors. So this would have, again, I wasn't aware of this one, but this is regionally nearby, obviously, with the city of Spokane. State of Washington. State of Washington. And then and there was another one that was there was a debarment for a city within Coeur d'Alene, or within North Idaho, excuse me.
Okay, so that's debarment. Now, how do you deal with a situation where there's a company that changes its name? So you have whatever, they change ownership. It's the same company, but it just goes under a new name. I mean, it seems like the current application process would be extremely biased against that.
If I honestly had seen La Riviere, like I said, if we had seen La Riviere as the applying company, we would have reviewed La Riviere. Simply as that. If they had made mention, hey, we used to be La Riviere and we are now Alpine, perhaps we could have reviewed it that way as well, but none of that was made mention. It was applied as Alpine Contractors Group.
Oh, okay, so there's really no consideration for that if a company just like if JUB decided to change their name to BUJ,
right,
then they don't have any history or anything. They just would be rejected because all that stuff that they've done doesn't count anymore.
Well, it would be the same company, and they would change the name in the state records, but it would still be the same company. So you file a document that says we are changing our name to this. It's not a separate company. It's not a new corporation, as it is in this case.
So I don't understand how this is different. It sounds like they're saying it's not, but you're saying it is. Can you come up to the podium?
If there's a buyout.
So they can get you on the mic, please.
Okay. If there's a buyout, sometimes you buy the assets and you don't buy the name. Sometimes there's, it's one of those situations where I think that that's very important. If the people who have the history are no longer there, then basically, what is the reason for the statute? What is the reason that says that you look at the body of work to determine if they're pre-qualified? They're under a different name. That's the same circumstance we're looking here. It's a different name, but the people behind the company are the same people. It's the same body of work.
If I may, for an example, I think everybody's aware that I bought Contractors Northwest.
You probably need to move over to the mic as well.
I think everybody's aware that I bought Contractors Northwest in 2016, right? Bought it from Dean Higginson, and we continue to do work. We took over the Contractors Northwest work. We continue to do work as CNI and as La Riviere and as joint committee, right? And so I've used my purchase of CNI in many, many, many pre-qualifications in the 4 western states as my work experience, not only my own work experience, but the work experience that I bought as well. And so I was able to use that in my pre-qualifications. This is, when I put this stuff together, that's the reason I put the La Riviere stuff in there. I understand what he's saying completely, but I didn't have a place to say, hey guys, it's me. We're the same, or we're connected, or any of that other stuff. There wasn't a place for me to perform that connection for you.
Yeah.
But we use a lot of companies. I mean, I've had several people make attempts at buying my corporation purely for me, right? And just because of the experience, because of all the models and all the different things that we bring to the table.
So you were aware of the debarment, and you knew that there were consequences to that?
Yes, in the state of Washington, yes.
State of Washington.
In the state of Washington. I never thought it was going to hit home. I never, not in a million years, it was going to be something here at home. As you mentioned, they didn't even look, I mean, I could have checked no, or I could have checked, I could have filled it out as La Riviere and checked no, but I wasn't going to lie, and that's not the purpose of what we were doing it for Alpine to do.
Okay.
We have our situation over there. It's literally 3 months from now, it's lifted. And it is what it is.
Okay, and Mr. Newell, is there any case law? I know you handed us a case here, a Supreme Court case, but we can't read it. Is there any case law of a debarment taking place in one state that doesn't hold in other states?
No, in fact, we've even we've researched that quite thoroughly, not only through my office, but also through Washington office. We have a large law firm over there who is handling that particular aspect. No, this basically is just goes down to fundamental law, is that you're not your brother's keeper, that under the law, a corporation is a separate entity and has its own rights and responsibilities. That's why everybody goes into corporations and LLCs, is to be able to create a new person. And by creating a new person, the fact that La Riviere was disbarred has no connotations to Alpine Contractors Group, because they were separate individuals.
I wasn't disbarred personally.
It was just a corporation.
It's debarred, I believe, is the
Yeah.
word. Disbarred is what happens to attorneys.
So what I gave you was in your packet of information was the Hillside Landscaping and Construction Company. The Supreme Court had a great opportunity to go in and to digest the present statute, which basically said that there are two different licenses which can or contracts in which you are either A or a B, and A is anything less than $200,000, where you have a contractor's license and you are eligible for that regardless of your experience or your qualifications. And then anything over $200,000, it goes down to a B, which says that the city can establish a qualifications and criteria, but it must be in accordance with the statute, which I gave you a copy of. And the statute says, political subdivisions, which is the city council, may establish pre-qualification standards premised upon demonstrated technical competency, experience constructing similar facilities, prior experience with the political subdivision, available non-financial resources, equipment, and personnel as they relate to the subject project, and overall performance history based upon the contractors, not the companies, entire body of work. You've heard me say that body of work about 6 times now. That's what they say in the statute. You look at the contractor's body of work, and that's Thomas La Riviere.
Randy, have you had a time to review that, or are you familiar with that case?
I have not had a chance to look at it, not familiar with it. I am familiar with the statute, which gives great latitude to a political subdivision such as the city in creating pre-qualification questions. The statute does not say what you can ask, what you can't ask. It gives you general parameters. I reviewed the pre-qualification questions before they were sent out, and I approved them. I believe they are consistent with Idaho law. And it just seems odd to me that they say we set up different companies to be a different company, but we can use other companies' experience. That's not how it works. Or it can work that way, but it doesn't have to work that way.
Also, the final question, if I can, to Randy, is there anything in Idaho code that prescribes what the city can do regarding debarment?
No.
So it's up to us?
It is up to you. It has to be reasonably related to one of these issues about demonstrated technical competence, experience, prior experience with the political subdivision, etc.
So that's what JUB was wanting, was us to basically codify what debarment would mean and what effect it would have and whether it would matter if it was in another state.
Right. I mean, we are a city, and we wanted to take into consideration situations where a company has been debarred by another city.
State.
You know, we're all in the same boat to some degree. All cities want contractors that are competent. It's shorthand for saying if you're debarred by another city, we don't want you either.
Okay, thank you.
It is for a limited period of time, and it is only in pre-qualification situations.
Randy, we've gone far and wide here with all these different questions. I would appreciate it, before we do any more questioning, to see if we can't funnel this down to what the issue is, because I heard Mike say the irrelevance of the debarment, because when they got to the point where they were looking at what the prior work of the company that was applying for pre-qualification acceptance, that there was no work to check on from that company.
That's my understanding of what wastewater determined.
So what should the council be looking at now? You guys can go ahead and have a seat.
But the question was, or the requirement in the pre-qualification is to list projects totaling a combined minimum of 20,000 lineal feet of pipe and identify those projects to show that the company that is applying has the relevant experience. And the only 2 projects that were listed were projects that were done by La Riviera and not by Alpine, either not Alpine Northwest LLC or Alpine Contractors Groups. If Alpine Northwest has been in business since 2011, and yet they didn't list any projects that Alpine Northwest has done, it's difficult to say a person can say, I can bounce around from company to company and take my experience with me. But what the city is looking at is the experience of the company that is actually going to be the contractor for the city, not the individuals, not the employees. Also in this statement of qualifications, I know Mr. La Riviera has said that he owns the companies. On page 4, list of executive officers, it lists Ronald Sanders as CEO and Thomas La Riviera as a shareholder. It doesn't really clearly identify what entity we're looking at, other than what they said on page 1, which was Alpine Contractors Group.
One other thing,
Uh,
Mr. Mayor.
Please stop.
I have-
Please
I have 3
stop.
minutes of rebuttal.
Yes, he does.
You have had a lot of time to share your thoughts.
Gets
I mean,
paid
we
by
can
the
go on
bird.
all night, but we're not going to do that. The basic question here is whether you want to support or deny the issue of not debarring, but not allowing the pre-qualification of this particular company, and that our staff did that refusal based on the fact that the company that they were examining had not done any work. The work was by a company by a previous name. Now, you can keep asking questions all night, folks, but this is really the essence of the question. And so that's what you need to make a decision on. Randy, would you have anything to add?
No, I think that's all that they failed to qualify on at the time, was that the experience was not the experience of the company that is applying.
Mr. Mayor, just one question. This won't be the last project for the city of Coeur d'Alene. So in the future, if they were to bid, what's the appropriate way for them to bid on a project?
Well, the appropriate way would be to bid on the company that's done the work that they're relying on for their experience.
So La Riviere.
La
If they want
Riviere,
us to consider
or
the
if Alpine
experience.
Northwest had some projects, they could have put those projects down. And again, this only applies to pre-qualifications. If you did a simple bid for a project, there's no pre-qualification, there's no debarment, there's none of that. If you have a public works contractor's license and you're the lowest bidder, you get the contract. So we're only dealing with pre-qualifications. It's not that La Riviere or Alpine are forever forbidden from doing any projects for the city at all. It's just this pre-qualification.
Thank you.
And remember, typically they don't do pre-qualifications. It was on this particular project where they felt they needed the expertise to lay this particular kind of pipe. It's that simple and straightforward, in an open trench manner. So you need to make a decision, council.
Is there a hearing? Have we closed the hearing?
There is no
There's no hearing. Okay.
Mr. Mayor, I have just a couple more comments on the pre-qualifications for doing this. It seems like there are low bid jobs, but this pre-qualification thing is going to come up again. And it looks like this triggered a conversation regarding how the city's going to deal with debarment. So this is going to change what happens in the future with pre-qualifications. And Christy, to your point, experience can be bought. Companies buy other companies because they want their experience. And so I'm feeling like this refusal was legitimate in its face value, that it was based on the information that was presented, but the concepts behind why it was presented that way are not uncommon. And I've seen it done in I don't know, in the construction business. If they pull together companies that have a lot of, sewer and pipe fitting work, and they pull together another company that has done just drill and blast because they need that license for a particular job, and they buy that licensed company. So you do buy the experience, and starting another company isn't uncommon in a lot of different industries. So I think that, for me, I think that we have a couple things that this decision's going to change. It is going to change how we look at the debarment effect. I think that's part of our decision. I think that we can't there's no statute about it from state to state, so we're kind of making our own way here, and this decision will affect that. This company can still do work for us and bid on us again, and our debarment may expire when the other debarment expires. So that's a whole bigger thing. They made a mistake in Washington. They were held up for 2 years. They paid their debt. It doesn't necessarily mean they're not a qualified contractor. So we have to come to a decision tonight whether we uphold our.
Well, I think it's fair to the appellants.
Mm-hmm.
And quite frankly, you need to go back to what Randy and I were saying. Debarment isn't really the issue here. That is not the issue.
Actually, I have a question specifically on that. In the City Council staff report, and it says a decision point should council sustain their decision, and the background information, and part 3, right there in bold, overall performance history, immediate disqualifier if not met, is the contractor disbarred or prohibited from working for any governmental agency or is any of its work not being accepted? So it sure seems to me like it's in the discussion mix. I don't know how you separate it and just, I mean, with the, the prevailing wage there, I mean, to back up, I mean, we're talking about, union prevailing wage, and governmental entities have a decision point. Do we want to go after X pot of funding, and it comes with that, and contractors who bid on it have that decision point. If we do, then this is what it is. When I was at the county, we went through that all the time, and I think, I've just gone through the process, it's on a much smaller scale, but where we bought this little counseling clinic, and then because of the billing stuff and all of that, there's like something that's tied to your personal license and then to the business, and so we created, the existing name was Healing Hearts Mental Health, and we created Steps to Healing, as a DBA, and so it does get kind of squishy. On the other hand, I have just completed my most recent application for a fingerprint background check and all the stuff you got to go through, and there's a whole laundry list. Have you done anything that would disqualify you somewhere else? Because the prevailing wage, provisions, in my understanding, that's federal, not state by state or, town by town. So, that's my background. So I think it is. I guess, Randy, is it
money on a state job.
Germane to this? Or, well, I guess the other final point that I had is that, I understand that people, create new business entities for different things. And on one side, they do it because it provides some protection and this and that, and it's of value. On the other hand, you're trading off that you're Mr. Nobody at that point. You really are starting just fresh. Now, if you start a new company and you've got employees and they look at that, but there are some trade-offs there. And again, this isn't, a permanent thing or meant in any way to be a black mark. I know the work that, the company has done with our Atlas project, all kinds of things. So that's not in question, but anyway, that's my 2 cents.
Mr. Mayor, if we don't sustain this decision, what happens? They go back and they go in with the pool of applicants and they're
Actually,
graded?
if you don't make any action, doesn't the decision of staff stand?
Well, I think what she's saying is if you reverse the decision, what happens? If you outright reverse it, then yes, you would then declare them pre-qualified, and they would be entitled to bid on the project, which if they're the low bidder, they would be awarded the project. If they're not, then they wouldn't get the project.
Okay. And how far along are we on the process?
We have pre-qualified 7 of the 10, so 3 were not pre-qualified. And as soon as this appeal is completed, whether it goes to the next level or not, then the city's going to have to advertise for or send out bid notices to those 7 and solicit actual bids.
So I think the problem I see with that is that they've all met these pre-qualifications, yet Alpine, in the form it is, certainly nothing against your history and your work product, in the form it is, has not. So is that differential treatment?
Well, it would seem to violate the pre-qualification process that was adopted in this case.
So we could find ourselves on all those other 7 companies appealing as well.
Sure.
Because they've been treated one way and allowances are made on the other side.
If Alpine ended up winning the bid, they might, yes.
They would. Maybe, Mr. Mayor, one more question. Randy, in our options here, there is an option to remand the matter to the selection committee for further proceedings. What would that be?
That would be if you questioned whether the committee that pre-qualified considered everything that they should have considered. Then you can ask them to reconsider what they did.
But can they use information that they've heard this evening, or do they have to base it on what the prior submission was?
They can use additional information, but they would still be they would still have these pre-qualification standards that have been adopted, so the council would have to tell them that we don't like those pre-qualification standards, which would, I guess, put all future pre-qualifications in your hands.
We don't want that. I think what
Mr. Mayor, since you're just ignoring us, because I know, I understand. So when did we adopt this? And did we adopt it?
Adopt what?
This approval, this created thing that's created
The
this.
pre-qualification
process.
is under state statute. It has been around for many, many years.
But you said
And in
you
each
wrote it.
pre-qualification, the city, the department that is pre-qualifying, comes up with criteria to use that they believe is appropriate for that.
Gotcha. So it doesn't, we don't really see it, we don't vote on it, we don't talk about it.
No.
So my question kind of comes up is, if we had to, would we have seen it this way? Would we have looked at it differently? I'm kind of going back to way I remember this city was, the words I learned was gentle touch. If you make things better for things, if you make things more universal, if you make things more fair because you mess up or make a wrong turn away, that was the spirit of what this was about, like traffic courts and, I was speeding, but my daughter was dying in the back seat. Or, for example, the guy in the parks, the concert guy that decided to spend all his money and not pay us. We didn't 86 him. We said, hey, just get us paid and you can go. That's kind of where my head's at on that. I hope that helps. I'm probably sure it doesn't. But
Mr. Mayor?
Yeah.
I think one of the dysfunctions here is this is a purely administrative issue. And here we are, policymakers, trying once again to deal with an administrative issue.
Don't you love it?
Yeah, but that's again by statute. I mean, that was presented in the packet to us that when a conflict arises like this, they appeal it to the governing body, which there's really no history of this kind of stuff happening, and it really shouldn't happen. There should be another mechanism, because we deal with policy. I mean, we should be discussing whether debarment in another state should be relevant here. I mean, that's kind of the issue that we would be dealing with, not whether this should go back to an administrative process that sounds to me like it's just going to end up the same way.
That's why we have hearing officers.
Yeah, they handle this stuff for us. So that's our dysfunction. That's why we're going kind of nuts here.
Mr. Mayor, may I make a motion?
Okay.
I would like to move to sustain the decision that Alpine Contractors Group failed to meet the pre-qualification standards.
And I would second, again, based on,
And I'd also, under discussion, if I can keep going, I think that the case being presented that this company is moving from one name to another company and all of that, it makes sense. And buying the qualifications from his previous company makes sense. And utilizing, so if it's a timing issue that the DBA was filed after the application was filed, this is all an administrative fairness. The moves make sense, the experience makes sense, and down the road, I believe Alpine Contractors will do work for the city, but the basic decision based on the information put in front of the folks who selected the pre-qualified group, it wasn't all there. That's kind of the end of the day for me.
Yes.
Thank you, Mr. Mayor. So I'm going to oppose this. No surprise there, because I'm typically the one who opposes things. I am just uncomfortable with us subjugating us to the rules of another state that we don't have any control over. And, I mean, whatever goes on in Washington, I mean, that's for them to decide. And it does seem kind of unfair for us. They aren't even our rules. And I don't even know if I would have agreed to the rules that they have over there. And I understand it was, you took ownership of it, and I really appreciate that. And it does seem kind of weird that you change the name right at the same time this happens. That's kind of a convenient coincidence, but that doesn't matter to me because I don't want Washington to tell us what to do. Either one. I've had a name change in my own personal business. I went by one business and then I changed the name, and I didn't have to reprove myself to anyone because I was the same person. So I understand that. I don't think that should be a disqualification. You got to understand that even if this did go back, if this motion fails and it does go back, there's no guarantee you're going to get the project. And you know this because you submit to projects all the time. There is kind of an unspoken thing that I shouldn't say, which goes on in the city, which it's widely known that if it's above ground, it's Welsh Comer, and if it's below ground, it's JUB. And I hate it that people say that about us because it does show that we have a bias. And I would like it if we would be a little bit more proactive in trying to find other firms to do our engineering. There are more than 2 engineering firms in this city. Thank you, Mr. Mayor.
Dan?
well, just as a, kind of final statement on my vote, I think we, and what Woody was saying, I mean, there's a lot of, kind of common sense and compassion and things, is kind of weighing on one thing, but also we're a rule of law, and this is a pretty clear-cut, defined process, and the things about the, some of the prevailing wage and some of those things, those aren't state of Washington things, they're federal, and, can disagree to not take that or something, but I think just to uphold the process and at the same time encourage, it sounds like, there's other stuff coming up and you're pretty close to whatever their clock ticking. So, I mean, hopefully, we would see La Riviere on lots of bid projects down the road. But for this one, going on this, and we've got to decide on what we've got here in front of us tonight. I mean, I'm not happy, but that would be my decision.
And, Mr. Mayor, so just going to get into, but I guess this triggered that discussion, and that's what kind of makes me a little bit uncomfortable. I want to sustain where we're at with it, but.
And I believe that it's just, are you currently debarred in any state? But I'm not sure.
I think that it did say, have you been, or is that the decision? My point being is that somewhere down the road, when you buy another company to build a new company, you create a new company, you should not have to just start from scratch with not using any of the experience licensing or training that you've gone through. But if what we're going to say is any company that does that for forever, and one of their companies that they purchased was debarred at one time, then we've set a precedent here. So that's kind of my
I think, though, it's
closing
important
thoughts.
to recognize that when Mike and his group were considering the different contractors seeking pre-qualification, they were not aware that this company was subject to a debarment in Washington. They were focused on the fact that the company name
Didn't
did
match.
not have history to check. It's just that simple and straightforward. So that is really the issue, not the debarment. Had nothing to do with Washington. And it had nothing to do with Washington telling us what to do. Christie?
Thank you, Mr. Mayor. I think the reason that we're struggling is because we think you're a good company, we know you, we like you, but I'm going to have to vote to support the integrity of the process. And I really hope that you come back to the city numerous times in the future, whether it's Alpine or La Riviere. But we do have to support the process. And that's just where I'm going to end up.
Will the clerk take the roll, please?
McEvers,
No.
Gookin,
No.
Yes.
English, Wood,
Yes.
Evans,
Yes.
Miller,
Yes.
Motion carries. Next on our agenda, we have an agreement with the Downtown Association regarding the St. Patrick's Day Parade. Renata?
One second, let me clear the screen here. Okay, I'm bringing you a little agreement. I wanted to assure you that I'm still working with the Downtown Association for a master agreement for all their larger events. We just are on a tight time frame for St. Patrick's Day. It's hard to believe that's just a short couple weeks away. So we wanted to bring this one forward to you. Again, this is the same format we're going to be using for the master contract, kind of sets out whose responsibility is what for this one. The St. Patrick's Day Parade is a short parade, and it is deemed a low-impact event on our fee schedule, so it's one of the smaller ones that we do throughout the year. So the map up on the chart, up on the screen here, demonstrates to you that the parade starts at 8th Street and goes to Government Way, or First Street there, with the breakup going up Government Way. This is the same plan that our Streets Department put together for last year. It's in coordination with the Downtown Association. They put out all the no parking signs that they pick up from our Street Department, so our Street Department doesn't have those extra duties tapped on to them. The Street Department will bring the barricades down the day of the event and set up the alternate route, and the Downtown Association will have the volunteers there to help man those intersections. So we feel like this is one that we've kind of divided and conquered on, and it's more of a 50-50 event of who's doing what, and we feel pretty good about the agreement before you for just this one, and rest assured, the rest will come forward to you before the Coeur d'Alene event. I have it all drafted. We just haven't had enough time to sit down with the Downtown Association and negotiate a few little elements, but I'm hopeful that within the next few weeks, we'll have the master contract ahead of you for you to take a look at. So I stand for questions.
Questions? Well, you did a great job. No questions.
Ready to be done.
Mr. Mayor, I'd like to move for approval of Resolution 24017, approval of agreement with the Coeur d'Alene Downtown Association, Inc. for the St. Patrick's Day Parade.
Second.
Motion is second. Will the clerk take the roll, please?
Gookin,
Aye.
English,
Yes.
Wood,
Yes.
Evans,
Yes.
Miller,
Aye.
McEvers.
Yes.
Okay, now we get to the noise amendment.
And Troy said I had 30 seconds to.
Yes, the polls are closing in California.
Well, now you only got 20.
All right, I'll stand for questions. Good evening, Mr. Mayor, council members. Tonight I'm presenting proposed amendments to the city's ordinance regarding noise from motor vehicles in particular. These regulations are found in Municipal Code Section 10-80 or .80.010. Subsection A of that ordinance currently consists of 3 parts. The first part prohibits the use of air compression brakes in the city except in the case of an emergency. That's continuing on into the new ordinance. The second part prohibits the operation of an automobile, motorcycle, or anything else with an engine in a way that creates loud, unnecessary, or unusual noise that is excessive, disruptive, or annoying to a person of reasonable sensibilities. That's all legal mumbo-jumbo, but there are lots of cases that say that those words are good enough for a statute, good enough to enforce. The third part prohibits the emission of excessive or unusual noxious or odorous exhaust, smoke, or anything else from a vehicle. The second and third items, 2 and 3, were added to this ordinance in 2017. Also in 2017, council added subsection B that allows the city clerk to permit an event which might otherwise violate the noise ordinance or exhaust prohibition upon the recommendation of the city administrator or parks director. You know, this was a section that was primarily added for the benefit of Coeur d'Alene, but is not specifically limited to that event. Finally, the current ordinance provides that a violation is an infraction, and the penalty was set at $100. This penalty predates the 2017 amendments. Before and after 2017, the city received complaints about noise from vehicles, most often along Sherman Avenue, but in other places as well. Many of the complaints concern practices of revving an engine while stopped in traffic or at a stoplight. Some vehicles, of course, are louder than others naturally, sometimes through intentional modifications, sometimes through original design. But that's not the only concern, the revving of the engine. Motorcycles in particular seem to draw attention to themselves and draw their fair share of complaints. But other vehicles besides motorcycles create noise and exhaust. State law currently prohibits excessive or unusual noise and annoying smoke. The statute further provides that required noise suppression systems and exhaust systems have to be maintained in good working order. Also, that all motor vehicles have to be equipped to prevent excessive fumes or smoke. Under state law, the term motor vehicle includes a motorcycle. There was a comment made during public comment that this amendments to the ordinance would prohibit equipment on various vehicles. Actually, the proposed amendments prohibit modification to the equipment of a vehicle, and we'll get to that in just a minute. In developing the proposed amendments, I looked at ordinances from many cities, including Boise, Caldwell, Meridian, Pocatello, Spokane, Twin Falls. I neglected to look at the French laws, but I could if council would like me to do so. I worked with administration, I worked with the police department, I worked with the city prosecutors in preparing the proposed amendments. All 3 administration, prosecutors, and the police department approve of the amendments as they have been presented. I reviewed the complaints that have been sent into the city, usually through the Municipal Services Department or administrator. From the prosecutors, I received advice regarding incorporating some of the state law into the city ordinance. And from the police department, they particularly requested that the fine be increased
Still an infraction for a first offense, but increased to the maximum allowed by state law of $300. The proposed amendments include the following. We're retitling Chapter 10.80 to be noise and exhaust instead of additional prohibited conduct. It just gives more notice of what the chapter provides for. There's a new Section A that includes definitions of 3 terms. Some of the cities that I looked at thought that definitions were important, so we included that. There's a new section that talks about the purpose of the chapter on noise. It's often important to include a purpose in an ordinance. It helps interpret the substantive portions of the ordinance. And here the purpose identifies the problem, which is excessive and offensive motor vehicle noise and exhaust. It identifies the importance of the problem. Excessive and offensive noise is detrimental to the public health and safety. And it identifies the intent of the ordinance, which is to regulate excessive noise and smoke. The proposed amendments change some of the numbering so that the new sections can be accommodated. But the important modifications, amendments, are in 10.80.010. And in that section, we include more details on the prohibited conduct, specifically talking about mufflers and bypasses and noise suppression systems and the actual operation of motor vehicles. The gist of the ordinance has not changed. We're just becoming more explicit so that people understand that you can't take the muffler off a motorcycle to make it louder. You can't modify the noise suppression system to make it louder than when it came out of the factory for the purpose of creating noise. And we also created an exemption that was also recommended by various people for antique and classic motor vehicles that are operated solely on private property. So we're not going to regulate that. We're only regulating or attempting to regulate motor vehicles on public streets and in public property. Finally, pursuant to the police department recommendations, as I indicated, we are suggesting that the fine be increased to $300 as the maximum for an infraction, but also that if you have more than one violation in a given year, then any subsequent violations would be a misdemeanor. Now, it would be nice to go back to simpler and more quiet times, but we believe that the amendments will help address the issues that previously have been identified by council and the public, and give the police a little bit more specificity to enforce in the downtown area. And I'll stand for questions.
Christie?
Thank you, Mr. Mayor. Randy, as I read it, we're comporting with state law, essentially. And it's always a good idea to give more details for officers to work with. Trying to interpret code sometimes can be very difficult when you're the officer writing the citation. So I don't have any issues with this whatsoever. I want to address the noise that we've had complaints about. I also absolutely support addressing big gray, black clouds of exhaust. And I think that there's quite a bit of latitude in here for a first offender. You're going to get a $300 ticket. That's not fun, but don't modify your equipment and don't make excessive noise, and you're going to be fine. And so you're going to get a warning, essentially. And then I suppose if you decide that you want to keep modifying and creating noise, then you're not going to get another good warning. You're going to get a misdemeanor. I actually think that you have found a good compromise, and you're comporting with state law. So I will support this.
Woody?
So I have three questions. For a violation, does a policeman have to be there, see it?
For an infraction, yes.
Infraction of a violation. He has to be there, he has to see it, even though they call him and say, hey, there's people going fast on my street. By the time he gets there, wait, he's got electric bikes. Okay.
Enforcement is always an issue for not just this ordinance, but any ordinance.
Okay.
And so, yes, not everybody's going to get caught, but hopefully the fear of being caught will help people comply.
On the modifications, who decides it's been modified? If you pull him over and it sounds like it's modified, and you ask him and he says no, does a mechanic come and say, oh, it's been modified?
No, it's like any other citation. It's something the police are going to have to identify at the time and decide whether it has been modified. I don't want to name names, but I asked a certain person who works in my office about her motorcycle. And she said, yes, I've modified it to make it noisier. And the item that's on it has a different manufacturer's name on it. I mean, sometimes the modification is obvious because it's not, Honda or Harley or whatever. It's some aftermarket manufacturer.
You don't have to roll under the car and look, right?
I don't think the police will want to do that.
My last one is, so you have this noise, do you have to measure it? Is it a certain decibel?
No,
Is it?
there's no decibel reading in this. It is, as I said, a relatively established legal precedent that you can say a noise that is offensive to a reasonable person. An officer can base that on just his own observations.
All right, thank you.
Other question? Yes, Dan.
Thank you, Mr. Mayor. So, yeah, I was going to comment on that. Thank you, Woody. The reasonable person fallacy. And it was mentioned during public comments about a dB meter. So it's going to really be up to, it's subjective.
It is subjective, but a lot of things are. And I've been told that our dB meters have to be calibrated every year or two at the cost of $700 a piece. So it's not an easy or inexpensive thing to have a dB meter with every police officer who is patrolling downtown.
Yeah, I know, and I agree, we should do something about the noise. It's all about enforcement, and, hopefully those new bikes can catch them, and they're not going to make any noise. The problem is downtown is a canyon, and so you hear the sound 3 times, which makes it sound a lot louder. And some of those things that you would hear on an open road, you wouldn't think about it out in the country, but you get in a canyon, it's amplified. Again, it's subjective. I do have a concern about the modifications, because to me, the vehicle modification things seem to be more about, is targeting someone who just wants to trick out their car,
Make it louder.
Make it louder to make it louder. And to me, that seems like it's already covered under Section B, which is just any sound made by a motor vehicle in any condition, speed, or whatever that's offensive to a reasonable person. It's, it triggers it. So it seems like we would be adding an extra step for the police to prove that something was modified when they could just say, no, that's really loud, and I'm going to write you the ticket based on that. I mean, would that ever come down to that, where a cop would have to actually prove, like Woody said, that, oh, it's been modified and therefore, I mean, it just seems to me that if we were going to say, hey, if it's loud and it's subjective to a reasonable person, why do we need to drill down to those details?
Because we were requested to, but there is still in Section 4 of the proposed amendment on page 2, subparagraph 5, talks about just the general operation. Any operation that in such a manner as to create excessive noise is a violation. So under that subsection, you wouldn't have to prove a modification.
Yeah.
And maybe it's redundant, but there was concern that we weren't inclusive enough
of all the possibilities of excessive noise.
Actually, the modification is more of an issue related to somebody who is cited for loud noise. He says, well, I can't help it. That's just the way it's manufactured. Then you would have that kind of an issue where it's, no, it isn't. I've been reading articles on this in my car magazines.
Wow.
And because it's not an issue just here. But basically, that's what they do, is they go after, well, then don't modify it from the way it came from the factory, because quite frankly, Harleys are noisy anyway, even if they aren't modified. But that's what they get away with, that level of noise. And really, it isn't so much, if a Harley goes down the street and they do a little bit of revving, it's no big deal. But when somebody's at a standstill and trying to show off and trying to get attention by revving their motor, that's the irritant, that's the frustration that people experience. And you know what I would say? We should close off Sherman from 1st to 7th, because that's where they want to show off, in front of the bars there. If they couldn't be down there with their bikes, then there would be no way to show off.
I'm sure Emily loves that idea.
Let's do
I have a
that.
question. So why, so you have all these noise suppressions. The most annoying sound I ever hear on the road are those people with the basses in their car, and they crank up their music and it rattles every vehicle within a 300-foot radius. Why isn't that in here?
It's under the general
That's a different
subparagraph 5.
part of the ordinance.
If they're operating a
See,
vehicle.
so to me, if that's under general, then all those other modifications could be under general too.
You wouldn't have an argument from me, but
Who asked you, by the way? Was it staff or was it someone outside the city?
I think it was someone some people I was looking at.
All right, thank you.
People in high buildings.
Yeah.
Mr. Mayor?
Well, go ahead.
And I would just make a point that we pay our police officers based on their experience and their judgment every single day. And people are innocent until proven guilty. They all have the opportunity to take their citation to court. So I don't know that we need to focus on will they not get it right, because all day long we trust them with their judgment. And people have due process.
And the police don't cite everybody for every violation. They have the discretion to say, go get this fixed or stay away from the downtown.
And they got to catch us. You said that too.
They got to catch
They
you.
got to catch us.
They'll be looking for you, Dan.
Mr. Mayor, I've been asked this question a lot in a bunch of different contexts, and I actually talked to Chief White about it a little bit today. And the question was, in this particular context, a shop owner near downtown had a repeat offender that liked to just kind of go up the street and then hit the rev, and it just blew the people out of their sidewalk cafe. The question is, if they had proof by videotape and submitted it to the police department on a repeat offender situation, will there be any action taken under the new ordinance?
It's difficult to judge the sound that people hear on the street through a video. So it's a matter of proof. Something can sound louder on tape or quieter on tape than it would in person. So I would say it's a matter of proof. The prosecutor would have to look at all of the evidence, look at what the police or what the person said about the noise. But again, a citation for an infraction has to be in the presence of an officer unless somebody wants to make a citizen's complaint.
Mr. Mayor, I thought, didn't we
I didn't call
pass?
on you yet.
Thank you. Didn't we pass a rule a few years ago that basically said that you could report something like that? I thought that was already on the books, because I remember opposing it.
Whatever it was.
I can't
All right,
recall.
because I thought it was already on the books that you could do exactly what Kiki said.
You can do a citizen's.
I'm sure you're
Yeah,
wrong,
but it's
and I'm
still a
losing
matter of
control
proof.
here rapidly.
You still have a matter of proof.
If I can follow up and Chief White had said, I think he actually threw Captain Walther under the bus and said, well, he's going to make him answer it tonight. So, and I see you hiding behind a post, so that's smart of you. But he did say it wasn't a cut and dried thing that the police wouldn't do. He said there could be investigation if there was repeat information and you could identify a driver and a license plate and all of that, that there could be some, so what do you have for us to share on that topic?
You know, what he's talking about is our policing model isn't always enforcement action in a traditional sense where a citation might be issued. So with the problem-oriented policing that we do, we would absolutely want to know that information, and there are a lot of ways to handle that that may not equal a citation. To issue a citation, like you said, you'd have to have a citizen sign the citation or be able to prove that it was the driver, the time, the license plate, the vehicle. But there are a lot of different ways to solve problems outside of a citation. So we would absolutely want to know about that to follow up and do what we do, but that doesn't always equal citation.
Makes sense. Thank you. Good answer.
How about a motion?
Yeah, I'll make a motion. I make a motion to approve, council approve amendments to chapter 10.80 of the Coeur d'Alene Municipal Code entitled Additional Prohibited Conduct.
Second.
We have a motion and a second.
Mr. Mayor, I would like to, oh, we got to dispense with the
Uh-oh.
rule first.
She'd like us to read the title 3 times.
No.
Yeah, let's do that.
I'll make a motion to dispense with the rule.
Second.
And then I make a motion to approve amendments in chapter 10.80 of the
Wait,
Coeur.
wait.
Oh,
She has
Oh, wait, you have to
read the
vote.
title, read-
Mayor dozed off.
First of all, will the clerk take the roll, please?
Evans,
Yes.
Miller,
aye.
McEvers,
Yes.
Gookin,
I don't know.
English,
Yes.
Wood,
Yes.
Motion
Gookin,
carries despite Mr. I don't know. Will the clerk read the title, please?
Council Bill Number 24-1002, an ordinance amending Chapter 10.80 of the Coeur d'Alene Municipal Code, regulating excessive fumes, smoke or exhaust, and excessive noise from motor vehicles, providing for the repeal of conflicting ordinances, providing for severability, providing for the publication of a summary, and providing for an effective date.
Now,
I'll make a motion to approve amendments to chapter 10.80 of the Coeur d'Alene Municipal Code entitled Additional Prohibited Conduct.
Second.
which is bill number 24-1002.
Thank you, yes.
Is that included in your motion?
It is, sir.
And your second?
Yes.
Will the clerk take the
Wait,
roll,
Mr.
please?
Mayor, please.
What?
I would like to make an unfriendly amendment to remove section 4A, numbers 3 and 4, if I can get a second.
Oh, you're killing me. I'll second for discussion.
No, you don't. I just think it's a little bit much. It's too much regulation, and that's why I'm going to go ahead and do that. But I know what the mood is, and I know that we're all real excited to be here another hour. So that's my, thank you for.
Okay, you heard the motion
that.
and the second to remove those sections. All those in favor respond with aye.
That would be me, aye.
Those opposed with nay.
Nay. Nay.
Motion fails. But you get credit.
I will take that to the bank, thank you.
So we have a motion before us to approve and adopt Council Bill number 24-1002. Will the clerk take the roll, please?
Evans,
Yes.
Miller,
Aye.
McEvers,
Yes.
Gookin,
Nope.
English,
Yes.
Wood.
Yes.
Motion carries.
Mr. Mayor, I'd like
Motion
to
to
move to
adjourn.
adjourn. Oh, sorry.
Second.
Motion is second. All those in favor respond with aye.
Aye.
Opposed, nay. We are adjourned.